Welcome back to #Lawyered. Today we're going to talk about what happens after the trial court renders a judgment. We've got our favorite appellate lawyer, Chad Ruback, here to demystify the world of appellate court law. Welcome back to #Lawyered, everybody. You got the A-team here.
Hey.
And actually one of our good friends, Chad Ruback, here to talk to us today about appellate work and what it really means to go through the appellate process. So Chad, thanks for being here, man.
Thank you so much.
Thanks for having me, y'all.
So Chad, he practices solely appellate law here in Dallas. He's been named one of the best lawyers in Dallas every year since 2005. And as we're learning, he's kind of a local celebrity here in the studio. A lot of people here in the Dallas community probably have seen Chad before because you're kind of a lot of news stations' go-to appellate court guy.
I like to show my face, except during COVID.
Right, naturally. Well, and like we talked about on the pre-production call, Chad, appellate court law or appellate law can be somewhat of a dry subject. We think you do a pretty good job of livening it up a little bit, so we thought you'd be a good guest to have here to kind of walk us through this process.
It is not the most interesting area of law. I would say it is probably neck and neck with tax law in terms of the most boring legal area to talk about, but I do my best to make it fun.
Yeah.
I think you succeed.
Yeah, no, I agree. So tell us, before we get into the actual appellate process and everything, tell us a little bit about your firm and kind of how you became so interested and so plugged in at handling appeals.
Accidentally. I graduated from SMU Law School in 1997, and my first gig was working for the Court of Appeals over in Fort Worth. I worked for a judge there where I helped her write appellate opinions. And I found that I enjoyed legal reading, legal writing, legal analysis, but I wasn't married to it. I wasn't tied to it. I figured I was going to be happy doing whatever kind of job I got next, be happy to expand my skill set. Well, that was not meant to be because every single job offer I got was practicing appellate law. So I never got to expand my skill set. I've never done anything but appellate law. So I've been doing a very, very narrow type of law for 23 years now, and when people ask me most legal questions, I say, I don't know anything about that. I know very, very little about most things, but I know a lot about this one narrow issue of law.
Yeah, well, and we're definitely going to jump into some of that here later about the difference or why it's important, trial versus appellate work. But I think probably the best way to get started for our listeners, we try to give them information and try to help them understand how different processes work so they're just a little bit more educated about what's going on in the world of law. But I think probably the easiest question to ask to start with is, how do we even get to the point where there is an appeal of a case?
Generally, you need to lose or you need to win. Very few things are subject to appeal before you lose or you win. A lot of people call and say, I don't like this ruling the judge just made. Well, you're not there yet. The Texas legislature has come up with a very short list of things you are allowed to appeal before the case is over. But if your complaint is not one of the things on that list, you need to sit tight, hold your horses, and wait until the case is over.
Yeah, and when you say win or lose, you're talking about you've had a full trial on the case, whether it's judge or jury, and you've got a judgment that's been issued by the trial court that's final and says, all right, this is our decision, we're not changing it.
That piece of paper.
I tell people you don't ever want to hire an appellate lawyer because if you're hiring an appellate lawyer, that means you've been in litigation for many years already. Yeah. You've become a familiar face at the courthouse. By the time you're up on appeal, you've been litigating for a long time. You've spent a lot of money. You've spent a lot of time on your case. Hopefully you never get to that point where you need to talk to me.
Yeah. Well, and in the appeals process, it can take just as long or longer.
Oh, absolutely.
Than the trial court process, right?
It can. I have one I'm working on right now. The lawsuit was filed in 2013. The case went to trial in 2016, got a judgment in 2016, was taken up to the Court of Appeals, same year, 2016. Court of Appeals ruled in 2019. It's now up in the Supreme Court. We're not expecting a Supreme Court ruling this year, so maybe 2020, possibly even 2021, and then it might go back to the trial court. So again, if you're dealing with the appellate process, you've been in litigation a long, long time.
And for our listeners who might not be familiar, when you say Supreme Court, in this context, you're talking about the Texas Supreme Court, right?
Indeed. I'm not talking about, Roe versus Wade. I'm talking about Texas.
How appropriate.
I'm talking about Texas procedural issues.
Yes.
Most stuff that's up on appeal in the state of Texas, is not going to be Roe versus Wade. It's not going to be should abortion be legal.
Right. Yeah.
It's going to be, a very, very esoteric issue of Texas procedure. And I have clients all the time explaining to me, what they think I need to know about their case. And invariably, the stuff they're telling me that they think I need to know about their case, it's no longer relevant. The facts of the case aren't a big deal anymore when a case is up on appeal. It's procedure, and it's boring, but it's something that a nerd like me enjoys.
So, but let's, kind of draw it back, though, to that timeline of when that piece of paper, that judgment comes out, right? So, we've discussed when the time to appeal is only after you've gotten that judgment. So say you have Rachel. Rachel has gone to trial on her case and she lost the trial court and she wants to appeal. What are the next steps Rachel's attorney should be taking if he wants to go ahead and file an appeal?
First step, if you're within 30 days of the judgment, is to file a motion for new trial. Occasionally, you can get the trial court judge to fix a mistake. And anytime you can get the trial court judge to fix a mistake, it's in your best interest because that means you don't have to pay me a lot of money. Also, it means you save a lot of time. If you can get the trial court judge to fix his or her mistake, you're not spending years in the Court of Appeals. So that's the first thing I think of after a judgment is signed. Next off, it's a simple form document called a notice of appeal. And people ask, well, how long is it going to take you to do that? I'm like, well, that's 5 minutes. It's a form you have to file. But that's what gets the ball rolling to do all the heavy lifting.
And then after that, everybody hears about briefing and everything. You want to kind of tell our listeners, how does that process work with briefs and oral argument and all those types?
And what is oral argument? Because everyone thinks of the courtroom in suits. We're over here, and the murder weapon, which I guess is a bad example because you do only civil appellate law. So there'll be, and the broken contract. Look at this evidence.
I'm smiling.
I'm waving it around. And so we have a full trial, right, when we're at the trial court level. But how are the dispositive hearings at the appellate level different than the trial court level?
First off, in the Court of Appeals, there's no witness stand. I have clients who all the time say, well, all I need to do is just have a minute in front of the court and I can explain to them all my story. And it's like, well, there's no witness stand there. You don't get to talk there. If there is, in fact, an oral argument, which is what an appellate hearing is called, it's only the lawyers that get to talk. It's on a really short time frame. Generally, it's 20 minutes per side, maybe with a 5-minute rebuttal. So, an appellate hearing, the longest one I've ever seen is 45 minutes long. And that might be for a month-long jury trial. So the appellate oral argument, the appellate hearing, is a teeny, tiny part of the process. It's the most visible part, so it's the part a lot of people think about. But ultimately, the appellate oral argument is just an opportunity for the appellate justices, the 3 judges in the Court of Appeals who are assigned to the case, to ask you a few questions about things they might not be entirely clear after reading all the briefing and reading the appellate record. The vast majority of the work in an appeal occurs behind the scenes. It's me closing my door and spending months sometimes reviewing trial transcripts, reviewing trial court filings in the record, doing legal research, drafting a 75-page appellate brief. It's not exciting to watch at all, but oddly, it's something I really enjoy.
Yeah. Well, and that's my experience, and I've never handled an appeal, but my experience just being in the legal profession is that the reason, oral argument's not even something that gets granted every time, right?
Correct. In civil cases, meaning non-criminal cases, it's granted about half the time. In criminal cases, it's granted even less. The vast majority of cases, the judges don't have any questions. They read one side's brief, they read the other side's brief, maybe they read a reply brief. It all makes sense to them. They don't have any questions to ask, and if they don't have any questions to ask, they won't give you an oral argument or hearing because they don't need you to read your brief to them. There's no jury in the Court of Appeals.
Right.
They understand the case already, and they have no questions. They'll just say, okay, we're not going to have an oral argument in this case. When they do have some questions, that's when they have an oral argument.
Yeah. And, so going back to the briefs, we use that term kind of flippantly, assuming everybody understands what that means. But, for our listeners, can you kind of explain what is an appellate brief?
Okay. First off, it's going to have a page, give or take, just explaining procedurally what happened. Party A filed suit against Party B, alleging these claims. It went to a jury trial. The judge signed the judgment, that sort of thing. Just very, very basic introduction to procedural what's happened. Then there's going to be a number of pages about the underlying facts. Only the facts that are relevant to the appeal, not just like, here's some interesting color commentary. You're not going to get very far with that. An appellate audience is very different from a trial court audience. You don't have a jury reading a brief. You don't have a jury hearing your case. You have judges who've likely been practicing for a long, long time, grading your papers, and what they're interested in are the legal issues alone. And so I often spend hours explaining to clients, listen, yes, that is a very compelling story, but it's completely irrelevant now. That window is closed. The type where you get to show your passion and all the reasons you've been wrong. That's over. Okay, that's behind you. Now it's time to talk about legal issues, and legal issues are not exciting to anyone other than someone like me or someone like an appellate justice who really truly loves a narrow esoteric procedural argument. I have clients who they look at an appellate brief and they say, well, I trust you that it's good because I don't understand. I'm like, well, if you did understand these legal arguments, then that means you've probably spent a lot of time in a law library. And by the time the case in a court of appeals, someone really just needs to hire an appellate lawyer that they trust, because most of what I do is not something that I could explain to someone in an hour or 10 hours. And so I'm trying to give you a 40,000 foot view.
Which is exactly what we want.
But I mean, this just isn't something that I could explain to someone in an hour or 10 hours or 20 years. It'd be like an electrical engineer trying to explain what he does on a day-to-day basis. I mean, he can sort of kind of tell you what he does, but in terms of the technical aspects of his work, you're going to be going to school for 4 years to learn that. It's not something he can tell you in a day.
Right. Because I mean, what you're doing in these briefs is after you lay out the case and everything, you're going and you're taking previous cases that have been decided by either that court of appeals that you're in or other courts that have something to do with the applicable situation you're dealing with in your appellate case, and you're trying to say, look, court, this is what the court has said before about this situation, and this is why what happened below is wrong, or what happened below is right, and you're trying to support your arguments by what's happened in previous cases, right?
Precedent is very important in the appellate practice, meaning what other courts have done, specifically what the court you're in front of has done, and also what some other courts have done. And when I say courts, I mean other appellate courts. So if a trial court did something over in, a random, Texas county years and years ago, it doesn't matter. It's what other appellate courts have done, particularly the court you're in, the Court of Appeals you're in, and what the Texas Supreme Court has done, analogizing those cases to your cases.
And that actually segues into the next thing I was going to talk about is everybody thinks, or not everybody, there's a lot of people that think, okay, if I don't like what I got at the trial court, I can go to the appellate court. If I don't like that, then I get to go to the Supreme Court and I get to have my day. But you don't, it's not the Supreme Court of Texas. But you're not automatically entitled to have an appeal with the Supreme Court of Texas, are you?
That's correct. First off, I tell people that an appeal is not a do-over. You don't just start over from scratch. An appeal is very, very limited in scope. Specifically, it's looking into what the trial court judge did wrong. Not about your case and how the other guy wronged you and why you should be wearing the white hat and they should be wearing the black hat. It's not that at all. It's about whether the trial court judge messed up. And a lot of people, I can explain that to, and they still need it explained to them again 5 minutes later because they're in the trial court mentality. And the mindset of someone in the trial court is frankly very different from the mindset of, someone in the Court of Appeals, or at least someone who's going to be successful in the Court of Appeals. Often the Court of Appeals is your last shot. It's your last hope to have your day in court, because Supreme Court in Texas, just like the U.S. Supreme Court, is a court of discretionary review. That means the vast, vast majority of the cases, they don't ever say whether the trial court got it right or wrong, whether the Court of Appeals got it right or wrong. They just say, no thanks, we're not going to take this case. A lot of people appreciate that when it comes to the U.S. Supreme Court. They know the U.S. Supreme Court can't take a fraction of the cases, that people want it to take. But the exact same thing is true of the Texas Supreme Court. The Texas Supreme Court only agrees to review about 10% of cases where people ask them to. So 90% of the cases that people seek Texas Supreme Court review, the Supreme Court doesn't say this side is right, this side is wrong, this judge got it right, this judge got it wrong. 90% of the case, the Texas Supreme Court just say, no thanks, this isn't a case we're interested in taking up. And they don't tell you why.
And so let's kind of swerve a little bit. So we've talked in prior episodes, in the Roe versus Wade episode that dropped recently, and then a few others, that when cases go to the U.S. Supreme Court, very often the U.S. Supreme Court tends to take cases that have a very clear fact pattern, and there's a very clear technical procedural issue that they can latch on to and explain. And so oftentimes the merits of these Supreme Court cases are decided on these procedural issues, not the actual substantive factual situations. Is that something that we're also seeing at the Texas Appellate and Texas Supreme Court levels?
In the Texas Supreme Court, that's absolutely true. One big difference in U.S. Supreme Court is they often take cases that have a big public policy concern, like abortion, for example.
Yes.
Yeah. The Texas Supreme Court doesn't have sexy cases like that very often. It's often interpretation of a narrow procedural issue. Let's interpret what this rule means. Let's interpret what this statute means. Often there'll be a disagreement among different Texas state appellate courts as to how, say, a statute should be interpreted. And the Texas Supreme Court gets to be the arbiter, gets to be the decider of which of those two appellate courts is right in interpreting the statute. So usually the stuff before the Texas Supreme Court is not at all interesting to anyone but an appellate lawyer.
So what's like an example of, you said that the Texas Supreme Court will take a case interpreting a statute, right? So what's an example maybe of a statute that the Texas Supreme Court would be interested in interpreting?
Well, I am working on a case right now that's involving construction of an oil and gas statute.
That's actually really interesting to me, but I'm also, an oil and gas and aviation nerd. So.
And there's not a lot of case law on it. So I'm citing 100-year-old cases out of
That's
the Eastland
real
Court of Appeals. Yes, it's fun for me getting to get out the old law books, like truly going to the law library because I can't find something online, and being very careful because the bindings are brittle.
Oh my goodness! Do you wear white gloves?
I don't, but I probably should.
Yeah.
So the stuff that I'm dealing with in the Texas Supreme Court, it's generally not something you're going to see on the cover of the newspaper. It's not something you're going to see in the news because most of it is really boring procedural stuff. I'm no fun at all at parties.
I disagree with that, but
I think you're a lot of fun at parties.
You just mean the cocktail talk. You're just saying you maybe don't have the fun stories.
Okay. When people ask, "Hey, Chad, what's going on at work?" I'd be like, "Well, I spent another 14 hours reading a trial court transcript." Was there anything interesting in that transcript? No. Not at all. I mean, it was very boring. It suits me what I do, but it's not something people want to hear about. So I'm really not sure why you invited me as a guest today, because what I do on a day-to-day basis, what you invited me to talk about, is the most boring thing imaginable. I mean, watching paint dry rivals what I do on a day-to-day basis.
But by the same token, though, on the big picture, and I appreciate what you're saying, but on the big picture, though, it helps what you do and the stuff that happens at the appellate court level. That shapes what we do in the trial court, right?
Yes, because ultimately, you don't win if you can't win in the Court of Appeals.
Right.
And I have to explain this to folks on a pretty regular basis is, it doesn't matter if you win the battle in the trial court. Yeah. If you lose in the Court of Appeals, you've lost. You've lost. And so I prefer to get involved earlier in a case rather than later so I can explain to people, the potential downside to things they're asking for. A lot of people, they're just so excited to win. They're so excited to get the judgment saying, I've won big. But ultimately, that's just a piece of paper you can put on your wall. If ultimately you lose that judgment on appeal, well, what good was that judgment? You've spent a huge amount of time, a huge amount of money to get it. If you can't keep it, what was the point of getting it? The analogy I like to use is driving your red Ferrari at 180 miles per hour in a school zone.
Jeez.
It might be fun for a few minutes, but ultimately when you're spending that night in jail and your Ferrari has been impounded, was it really worth the amount of fun you had? Did you really win? No, you lost. You had a couple minutes of fun, but ultimately, the downside is, far outweighing the upside. In the end, you lost. You're wearing black and white stripes, and your car, your car is locked up. Okay, in that 12 hours you're spending sleepless in jail. Are you really thinking you won because you got away with 3 minutes at 180 miles an hour in the school zone? No, you're not. And so what I like to do when people do hire me early enough to get my opinion is explain to people the pros and cons to their strategy. I don't ever tell anyone what to do. I don't tell the trial court lawyer, I don't tell their client, this is what you must do. But I do explain, listen, that might get you a good result in the trial court. But if you can't keep that result in the Court of Appeals, was it really a win? Not really, not so much. Sometimes there'll be a judge who gets really upset at one side. One side will really tick off the judge. In a situation like that, the other side, the side that didn't tick off the judge, needs to be really, really careful. Because sometimes when the judge is upset at one side, the judge will give the other side more than they're entitled to. I mean, you don't want $1 billion judgment, okay? Even if the judge will give it to you, if the judge says, listen, put any piece of paper you want in front of me and I will sign it, that's when you need to be really, really careful. And a lot of folks, if they're not in consultation with an appellate lawyer, they don't fully appreciate that. Wow, I was able to get the judge to sign a $1 billion judgment in my favor. Well, okay, what good does that do you? You're going to be spending a lot of time and a lot of money in the Court of Appeals trying to keep that judgment, which you weren't entitled to begin with. You're going to lose that judgment. Then you're going to be sent back to the trial court for a do-over, and you're going to have to start over to do it right. So you've wasted 2 or 3 years of your time. You've wasted tens of thousands of dollars in legal fees. You wouldn't have needed to waste that time or that money if you'd stayed between the lines to begin with, if you'd only asked the judge to give you what you can keep. So I like to advise folks how to get the best possible result that they can keep. Not the best possible result in the trial court conceivable, the best possible result in the trial court that you can keep. That will save you a lot of time. It will save you a lot of money. Ultimately, it is the best result for you if it's the best result you can keep.
And one thing to know, I think, too, is, Chad, how often, if you went to the trial court, you get that $1 billion judgment, which you likely won't keep at the appellate court, how often, if ever, does the winner actually get to touch any of that $1 billion?
Never.
See? There you go, right? There we go.
You get to touch a piece of paper you can hang on your wall, and you've spent a lot of money on something, you've spent a lot of time on something that's truly nothing more than a piece of paper. And yes, it's going to make you happy for a few minutes, like driving your Ferrari 180 miles an hour through the school zone. But ultimately, the next 12 hours you're spending in jail, you're not so happy anymore. It really wasn't a win. And that's what I tell people who get their $1 billion judgment, when they should have had $1 million judgment, is, wouldn't you have been better off getting that $1 million judgment and getting to keep the $1 million, as opposed to getting the $1 billion judgment and not getting anything to show for it in the end?
And that's the value that you add when you get involved early, is you can counsel the trial court lawyer and the client that, hey, look, you may be entitled to that $1 billion, but million's going to actually stay in your pocket, or have a better shot at staying in your pocket. And that actually segues into one of the big takeaways that we talked about for today is when is the best time, or when should you start considering to hire an appellate lawyer?
Same time you're hiring your trial court lawyer, before the suit is even filed. There are a lot of things that a trial court lawyer needs to focus on. Trial court lawyer can't focus on everything. Can't be thinking of every possible angle. And I tell people it makes sense to hire the trial court lawyer to persuade the trial court judge, to persuade the jury in the trial court, but the trial court lawyer can't be doing that while also worried about at the same time, well, what's going to be the legal precedent I'm going to be able to maintain down the road? One person can only be doing so many things. One person can only be focused on so many things. So I tell folks, hire a trial court lawyer to focus on persuading the trial court judge, to focus on persuading the jury, but hire the appellate lawyer to be thinking, what can we do to maximize our ultimate success on appeal? And I will explain to the trial court lawyer, will explain to their clients, hey, listen, here's some downsides of the strategy you're considering. But ultimately, I don't tell them what to do. Sometimes they will, heed my suggestions. Other times they say, well, Chad, we really want our $1 billion judgment. And if that's what they want, that's fine with me. I'm there to help present some thoughts they might not have considered otherwise. And if they choose to consider those thoughts and then decide, no, we want to get the most zeros possible, that piece of paper that says we're entitled to $1 billion, it's worth it, even if we can only keep it for a short period of time. That's fine. If that's what you want, if that's what your goal is, I have no problem with that whatsoever. But if you want to attain the best possible ultimate outcome, it makes sense to visit with an appellate lawyer as to what you can keep, not just what you can get in the trial court for a short period of time.
And I think that leads into the next question, right? So say you have Lucy, and Lucy has a case. I won't even say what the subject is. She goes and she hires her trial court lawyer for her case, and then she wants to know, is her case suitable or big enough to also then go and hire an appellate lawyer as well? What are the things in Susie's case that maybe Susie, I said Susie, I meant Lucy, can look at and evaluate that this case is worth the expense of getting both a trial court lawyer and an appellate lawyer?
Well, in terms of the subject matter of the case, that doesn't much matter.
Okay.
Any subject is something that should be considered for potential appeal. On the other hand, the size of the case, the dollar amount of the case, I mean, that's something that Susie or Lucy, as a businesswoman, is going to need to give some thought to. If there's only $10,000 she's seeking, is it going to be worth it? And I say only, that is a lot of money, but if in the legal system a relatively small amount of money, say $10,000 is at issue, is it worth bringing in a second lawyer? Is it bringing on is it worth bringing on someone who focused in a different area of law, such as appellate law? Probably not. On the other hand, you add in a 0 or 2 zeros or 3 zeros, well, that's what a business person like Lucy is going to need to give some thought to. If there's $1 million at issue, is it worth bringing on a lawyer in another practice area such as appellate law? Absolutely. I don't need to know anything else. I just need to know if there's $1 million at issue, then for sure it's worth bringing in another lawyer to bring in another perspective, a lawyer from a different practice area such as appellate law. If there's $10,000 at stake, no, then it's not worth bringing on an appellate lawyer. So I would say the amount in controversy, the amount of money at issue is going to be the biggest deciding factor for a business person like Lucy in making the determination as to whether it makes sense to bring someone like me on. On the other hand, I've had folks bring me on in cases where there's a relatively small amount in controversy. And there's some people out there who truly do value the principle over the dollar amount. Doesn't happen very often. I have lots of people tell me they do. This is about the principle, not about the dollars. And then I explain to them what it's going to cost them in dollars. And suddenly it's not about the principle anymore.
Funny how that happens, isn't it?
Principles are not as important at that point anymore.
I hear money is no object. And then I explain, well, here's the money we're talking about here. This is what you're going to need to spend to get you where you want to be. And suddenly they reconsider their money is no object.
Well, and so it's funny you mentioned that, because I actually want to tackle another myth or misconception, probably more appropriately, is that there's plenty of people that I know, because you've told us about this and we hear about it. They call and they say, hey, Chad, I just need 15 minutes. I'll tell you about my case, and you tell me whether you think we can win this on appeal.
Whether it's evaluatable.
Right.
In 15 minutes.
Yeah, and so, and then they're baffled whenever you say, well, it takes more than 15 minutes. Can you tell us a little bit about that?
If someone has a headache and they call a neurologist and say, I might or might not have a brain tumor, in 10 minutes, can you tell me if I have a brain tumor? No. I mean, that's not how it works.
Yeah.
It requires a lot of testing. It requires, some real analysis. It's not a 10-minute project. It's not a 15-minute project. I tell people who call me and ask me, if I can give them 15 minutes to visit with them about their case and help them evaluate their case, I let them know that roughly half of the work in the appeal is evaluating the case. So if it's a 20-hour project to do the whole case, hypothetically, it's a 10-hour project to tell them if it's a good case or a bad case. So at that point, once I've done the evaluation of the case, once I've truly evaluated the case, I've done half of the entire appeal.
Wow.
And it's just because it's so detailed, it's so intricate,
It
you're
is.
looking at so many things.
Well, I need to read the transcript.
Yep.
And for me to get the transcript, the trial court lawyer or his or her client needs to pay the court reporter for it.
Yep.
And it takes the court reporter sometimes months to get the transcript. A lot of people think, well, the transcript just somehow magically appears. No, someone needs to actually type it up. And that takes a long time and costs a lot of money. Not in a lawyer's pocket, but in a court reporter's pocket. I see some cases where I wish that I was the court reporter rather than the lawyer. I see what the court reporter's bill for a month-long trial transcript.
Yeah.
It's a lot of money and takes them a lot of time. So once they spend their month, 2 months, 3 months typing up the transcript, it could take me a month or two to go through it with a fine-tooth comb and find any procedural issues that might be, valid arguments to make on appeal.
Well, and I think that to me, there's another myth I want to tackle there too, is that people say, well, Austin, you're a trial lawyer, you can handle this appeal, right? Just you can go ahead and take that. And that's absolutely not the case and not how it works, is it?
Your words, not mine.
It is certainly possible for someone to be a talented trial court lawyer and appellate court lawyer, in theory.
Right.
I've never met that person. If he or she exists, I've not met him or her. The analogy I like to use is it's a bit like baseball pitcher, football quarterback. if someone were coming down from Mars, someone who knows nothing about human beings or sports, they would say, "Oh, look, Austin, that is a nice ball you have." I understand that people go into these things you call stadiums with tens of thousands of people and throw balls. That Martian would not understand that there's any difference at all between football and baseball. The Martian would just see there's someone in a stadium full of tens of thousands of people and a ball is being thrown. But to someone who knows a little more about the games, football and baseball are very different games and require very different skills. Maybe at high school, junior varsity level, you might have the same person who's a star quarterback and the star pitcher. Much less likely at the competitive level in college football. Still in theory possible. Once you go to the pros, okay, just not going to happen.
Right. We got like Deion Sanders and Bo Jackson, but that's two guys I can think of in the history of the sport that really hit the pinnacle of playing baseball and football.
And even though they were able to make the bigs in both sports, they didn't have equal levels of talent in both sports.
Right.
One might be a slightly better football player than baseball player. I mean, it was great that Deion was able to play Major League Baseball, but he was a better football player than he was a baseball player. Okay.
Yeah.
Bo was talented enough to make the majors, to make the bigs in both, but was he really a superstar in either for much time?
Right.
Probably not so much.
Right.
So I would say, if you have someone who is really the top trial court lawyer in town, that person's not going to be the top appellate court lawyer in town, and vice versa. You would not want me arguing to a jury. You wouldn't want me explaining to a jury why you want to win your case.
Yeah.
Okay? I would not be very good at that. Someone would be foolish to hire me to try their case to a jury, as opposed to hiring y'all, because that's what y'all do on a regular basis.
Right.
On the other hand, I think I'm pretty good at what I do in the Court of Appeals.
Yeah. Well, I'm sure Andrea's glad you got us back on track, because I could have gone down the Deion Sanders, Bo Jackson debate for a long time.
And I would be like, I Bo who? Sorry, people. I don't know. But, I do want to kind of swing this in a different direction. So, we've discussed the differences between trial court and appellate level. And, I think people are starting to understand that the appellate level is very mechanical, right? It involves working through things with fine-tooth comb. So with that in mind, are there any really interesting cases currently going on in the U.S. Supreme Court or the news or maybe here in Texas that you think have an interesting appellate component that people should know about or would be interested to know about?
I would say that the very most interesting matters we're going to be seeing in the U.S. Supreme Court have not yet been filed. I would say that in the next year, we're going to see all sorts of excitement in the U.S. Supreme Court. First off, we're going to have some election contests. We have a president who seems like he's not going to be leaving the White House peacefully. He's not going to leave without some kicking and screaming in the court system. And that's going to be the type of thing the Supreme Court might take an interest in. Yeah. We haven't had a president who was going into the month of January still contesting election results in my lifetime or my parents' or grandparents. That's going to be some interesting stuff to follow. Likewise, this is the most conservative Supreme Court we've had in my lifetime, that's for sure, and likely in my parents as well. That might leave the door open for the Supreme Court to reconsider some decisions it might have made in the past. Roe versus Wade is one y'all recently covered in your show. Well, is that set in stone? Maybe not. We now have a much more conservative Supreme Court than we had when Roe v. Wade was decided. We have a much more conservative Supreme Court than we had, say, 60 days ago. Is the Supreme Court going to be reconsidering some of its big decisions in the next year or two now that the Supreme Court is much more conservative than it's been in possibly ever? I don't know.
Yeah.
And when you say reconsider those decisions, is that typically when a court, and I'm going to use that phrase, reconsiders a decision that it had made in the 80s or the 70s, what have you? Are they typically completely overturning that case, or are they saying, well, we find this aspect within this case should be explained further, and so the room for discussion narrows, right? So for example, in Roe versus Wade, would they say, oh, this is completely overturned, or would they say, well, let's really focus, let's take a case and let's really focus on the concept of what a fetus is and viability, since that was important to the overall ruling in Roe versus Wade?
Usually the latter. Usually the court will not say, we just got it dead wrong the last time around. Occasionally, the Supreme Court will. One example that's coming to mind is separate but equal in schools. Supreme Court just said, we really screwed that up a few years ago. We're sorry. We're embarrassed of the awful decision we made. We're going to fix it. That's the only one that's coming to mind where the Supreme Court has just said, wow, we messed up. We're going to take it back. We got it wrong. More likely, it's exactly as you've explained it. It's a little more nuanced. You know, we'll narrow the scope of something, or we'll reevaluate one thing we said here. It might have a dramatic difference in the outcome, but it's more looking at a nuance rather than a throw the whole thing out like they did with separate but equal.
Yeah, no, that makes a lot of sense. And I think those are some really great things that our listeners can definitely try to look forward going forward, and gives us some more content to throw on the show itself.
And I think it really helps, you know, get ready for people to spice up the Christmas dinner or Hanukkah dinner or Festivus dinner that they're going to be having, you know, because Great Aunt Harriet, I'm sure she's going to want to talk about cases like that and how things are going to get overturned. And I'm like, well, let's think about that.
Chad, go ahead, Chad.
I was going to say, Great Aunt Harriet might even be more vocal this year than she had been in the past, because remember, she's going to be on Zoom this year.
Oh, yes.
So you're not going to be able to kick her under the table like you did last year.
That's a great point. Well, Chad, we talked about, a couple of things that we want our listeners to walk away with. One is hire an appellate lawyer early. Two is understand that trial versus appellate lawyers are, very different, like quarterbacks and pitchers. But I think one of the big things I wanted to leave our listeners with is something that you made very clear to us is really when you're looking at whether or not a case is ripe for an appeal, and I don't mean ripe in the legal sense, but it's a case that is appealable. You told us before, you're really looking at two basic questions that you have to answer and when you're evaluating those cases. Can you tell our listeners a little bit about that as we wrap up?
Sure. It's a bit of an oversimplification, but from a 40,000-foot viewpoint, the appellate court is only looking for two things. One, did the trial court judge break the law? And two, did it make a difference? So the client who's wanting to say, but I want to talk about who was right and, who really breached the contract and who lied to whom and whatnot. It doesn't matter in the Court of Appeals. That ship has sailed. Your opportunity to talk about that is behind you. In the Court of Appeals, again, oversimplifying it a little bit, but in the Court of Appeals, two issues. Did the trial court judge break the law, and did it make a difference? So if hypothetically, trial court, conducts a trial, trial's over, your client, Lucy, loses at trial. Lucy's not very happy about it. Judge signs a judgment against Lucy. Right after signing that judgment against Lucy, the trial court judge takes off his robe, takes off all his clothes, runs around the courtroom yelling, wee, wee, wee. Is that a basis for reversal on appeal? Well, for the first prong, did the trial court judge break the law? Absolutely, positively. The trial court judge broke the law there. For the second prong, did it make a difference? No. The trial court judge already signed the judgment, was not acting erratically before signing the judgment. Does that sound like a good appeal to me? No. It doesn't matter how egregious the trial court was in breaking the law. If it doesn't make a difference, doesn't matter. So you have two prongs without the other, doesn't matter in the appellate courts.
Gotta have them both.
Yeah, and I think that's probably the most frustrating thing for people to deal with is that, well, the judge got it wrong. Okay, yes, but the judge also could have made the end result decision on a number of other reasons, and so therefore it really doesn't matter that the judge got it wrong, and I'm sorry.
Absolutely. Judges are human. If I followed either of y'all around for a day at work, am I likely going to be able to find something you could have done better? Of course, we're all human. If I follow anyone around, even the best of the best at anything for 12 hours, that person is going to make a small mistake here or there. If I watch closely enough, I'm going to be able to find something. That doesn't get us there, though. Did it make a difference in the outcome of what you're working on? No. Okay. If you end up, spending, months, as I might, on an appellate brief, and there's a typo in the brief. I've had that happen to me before. I feel really stupid about it, but ultimately, is that going to make the difference? If everything else in my brief is rock solid, but I have one typo, it is a mistake. It absolutely is a mistake. Is that going to make the difference between winning and losing? No. Same thing in the trial court. If you can find a mistake the trial court made, if you can show where the trial court judge broke the law, that's important. But it doesn't end there. The inquiry doesn't end there. You then need to show it made a difference in the end.
Yeah. Mm-hmm. And I say it's an oversimplification, but I think it really frames it up quite nicely for our listeners, because it really shows this is what you're looking at.
Absolutely. And it makes the entire issue, or the entire, I think, basis of understanding appellate law much more accessible, right? Because even a lot of lawyers are like, so what do I do next?
Yeah. Absolutely. Well, Chad, thank you so much for being here. As always, we enjoy being around you, and I really do think that you helped spice this up, but more importantly, you really did explain and break this stuff down for our listeners so that they really can understand what happens after the trial court is over.
My pleasure, y'all.
Awesome.
Guys, thank y'all for listening. Stay tuned for closing argument. We've got some discussions about COVID vaccines and employment law and some other things that we think you need to check out here in the future.
Hey y'all, thank you so much for listening to #Lawyer Today. But wait, before you go, we want to make sure that you know where to find us on all the socials. So catch up with us on the audiovisual portion on YouTube. We have a #Lawyer channel there that we're very excited for you to take a look at if you want to put some faces to names. I know I love doing that. Make sure to follow us on our Instagrams, whether it be the #Lawyered Instagram or Austin's and my personal Instagrams. We check all three, so make sure to DM us or frankly leave comments on all of our latest posts to make sure that we're covering the topics that you guys are interested in. And if you have any questions or you're like, hey, I heard this in the news today, I think it's really interesting, I kind of want you and Austin to break it down for me and give the legal perspective so that I am well equipped at my next dinner party or Zoom cocktail hour, COVID and all that, to be able to discuss this with my friends. So again, thank you so much for listening. Make sure to rate and review the podcast on whatever platform that you're listening to. And we are so thankful that you're listening, and tune back in next week. Bye, y'all.
Today on Closing Argument, can your employer force you to get a COVID-19 vaccine? With COVID vaccines on the horizon, many people are asking whether or not their bosses or their company could legally require them to obtain the vaccine before coming back to work. The debate's going to center around at-will employment states versus union states, where there's a lot more restrictions, and I do believe there'll probably be a number of First Amendment lawsuits stemming from religious association arguments. Regardless of how this turns out, there will obviously be a lot of controversy, and we encourage you to go check this out and follow it.